estate investors probably of this whole presentation are most interested in is the property tax, and I think it's time that I have to quit, so sorry. No, not really. I've still got time. We talked about using an LLC to hold your real estate. It's really great from a creditor protection standpoint. It may or may not be great from a property tax standpoint. Basically, is there anyone in here who doesn't know what I'm talking about when I say the parent-child exclusion? Do you all know what the parent-child exclusion is? You don't know? Okay. So,
I have a child, so maybe I should know.
Okay. So the parent-child, let's just take, again, let's take an extreme case. 75-year-old client lives in Atherton, has owned that property since she was 25. She and her husband bought it basically when they were 25, so 50 years ago. Bought it for $50,000. It was an upscale community even then. So they bought the property for $50,000. It's on 3.5 acres in a prime section of Atherton, worth what?
4 or 5.
4 or 5, I'd say probably 7 to 10.
How much mortgage?
Probably none. God forbid that they should refinance it. Are you kidding? They're children of the Depression. No way. Mortgage? Okay, so they bought it for 50. It's worth let's say 7. If they sold the property to me, my property taxes would be 1% of value, right? A little bit more with the assessment. So they're paying, $50,000 purchase price. Let's be generous. They're paying $1,500 a year in property taxes because it's gone up 1% each year. I buy the property and my taxes go to $70,000. Just a little bit of a delta. If instead of selling the property, they say, I want my property to go to my children or my child. Let's start with the easy case. I have one child and I give my house in Atherton to my son Danny.
Like it already.
Like it already. Okay, so a couple things happen. Number
Thank
one,
you.
You're well, thank your mother.
You said say thank you.
Okay, say thank you.
I'm listening.
Okay, good. He's listening. A couple things happen. First of all, again, I'm not going to dwell on the income tax side of things, but your child receives a tax benefit when you die. The property gets reassessed. Remember, if mom had sold the property, her cost basis in that property was $50,000. She sold it the day before she died for $7 million. We've got a $250,000 exclusion because she's single, but there's capital gains tax on $7 million minus $300,000, right? The original 50 plus the 2. So we've got a kind of a substantial capital gains tax. On the other hand, escrow gets delayed and it doesn't close until the day after she dies. What's the capital gains tax now? 0. It gets what's called a step-up in cost basis on death. So the income taxes get wiped out as of date of death. Now, Danny basically holds it for another 4 years, and it goes from $7 million to $10 million. When he sells it, there's going to be capital gains tax on the gain.
3,000 minus.
3 million,
Minus,
thousand.
yeah.
Yeah, even lawyers know that there's an extra 0 in there. There's going to be capital gains tax on the increase, but there's not going to be any capital gains tax on all of the rest of that. $7 million estate, there will have been some estate tax that had to be paid, but we'll ignore that for the moment. In California, let's take it one step further. Basically, my husband and I have that piece of real estate that we bought for $50,000 in whatever it would be, 50 years ago, 1963. We bought the real estate in 1963. My husband dies December 31st, 2012. I'm still alive. I don't get, basically, it's not just his half of the property that gets readjusted, it's both halves. So, double bonus, community property. One dies, both halves get readjusted. Okay? So, mom can, sell the property and she doesn't have tax on $3.5 million.
Does the readjustment affects the property taxes?
No, let's not go there yet.
Okay.
Let me, because I know that there's people that are interested in the investment aspect of things and they may be inheriting property. Let me just take it one step further. Let's assume that it's not my personal residence. Let's assume that it's investment property, okay? Let's change it from the house in Atherton to a piece of commercial property in Palo Alto that I've owned, since 1963. The numbers aren't going to be quite as dramatic because it's investment property, but they're not going to be bad. Again, mom and dad owned it. One of them passes away. The entire thing gets reassessed. It's investment property. There's another thing that happens with it. Ever hear about a little thing called depreciation? You owned it for 50 years, so it's been depreciated to zero, right? Guess what? The depreciation clock starts again.
Resets.
It resets, another 20 years
Nice.
at full fair market, and now you're not taking it off of a $50,000 basis.
Right, like 500,000
You're
or $1
taking
million.
it off of a $5 million,
Right.
$7 million
Nice.
basis. So, your kids should be saying thank you. Now, those kids are basically on the phone saying, oh my God, I inherited this piece of property. I'd love to keep it because, hey, I don't know what the depreciation is on a $7 million piece of property over a 20-year time period, but let me tell you, I think you're probably going to be able to offset a lot of your regular income with that depreciation alone. And of course, it's all fully paid for because mom and dad didn't believe in mortgages, so it's all positive cash flow. But it's like, oh my God, the property taxes are going to go from $1,500 a year to $70,000 a year. That's an awfully big bite. Different rules for personal residences than there are for commercial property. California law says that a transfer, and by the way, a transfer means not only a gift, or either during life or a death, but it also means a sale. A transfer between parents and children of a personal residence qualifies for what's called a parent-child exclusion from reassessment of property taxes, which means that mom sells you the property for $7 million. You still get to keep her $1,500 real estate taxes, or mom dies and leaves you the property worth $7 million, you still get to keep that same $1,500 real estate bill. There's forms that you have to file with the county recorder's office, but you get this parent-child exclusion.
What if the parents give out to the children?
What if the parents give the house to the children? In the scenario I just described, it's a stupid move. That's a legal term. If mom and dad bought the house for $50,000, it's worth $7 million, and they give it to you, you take their cost basis, so you turn around and sell it the next day, and you've got $7 million minus $50,000 capital gains, right? Mom made a gift of more than $5.2 million, so if she's single, she has to file a gift tax return, and she's got to pay 40% of roughly $1.7 million to the IRS as a gift tax. Far better, frankly, to sell you the house, use, if you're familiar with the term AFR rate, applied federal rate. That's basically the minimum rate that the IRS says that you have to charge on a loan. Do an interest-only sale. Basically, she carries back the deed of trust. I don't know what the current AFR rate is, but on a 30-year loan, it's someplace don't quote me on it, it changes every month. For the month of August, it's roughly, let's say on a 30-year loan, it's, let's say roughly about 1.7%, maybe 1.8%. She does it as an interest-only loan to you. She will have to pay the capital gains, but remember, we're trying to reduce her estate anyway because we don't want to have, the capital gains tax rate is only 15 or 20%, whereas the estate tax rate is 40%. Difference, of course, being that it would be 15% or 20% of the entire amount as opposed to the incremental difference. But she can probably structure it as an installment sale, right? So that she doesn't have to recognize the money, she doesn't have to recognize all of the gain immediately. She only has to recognize the gain as she's getting the principal back on the value of the house. She might need, she's probably moving into a nursing home that around here for a decent one is going to cost her at least 10 grand a month. So she's going to need the income, right? You don't intend to live in the house, or maybe you do, but let's say you don't intend to live in the house, you're going to rent it out because it's a house in Atherton and you can probably rent it out for $25,000 a month, easily.
What a terrible investment.
Terrible investment, it depends.
Truly.
So you're renting it out for $25,000 a month. Again, don't have a lawyer do the numbers, but if I'm paying mom 2% of $7 million annually, that would be what, $140,000. I'm paying mom $140,000. That's deductible if it's an investment property. Mom has to report it on her income tax return, but hey, that's just about what she needs to live in a decent nursing home. So you've solved that problem, and you've still got the depreciation because now it's an investment property.
And you can 1031 exchange it.
And you can 1031 exchange it if you wanted to, but maybe,
Right.
yeah, maybe you don't. Maybe you don't want to. I mean, you've
Right.
got a really low property tax basis, maybe you think you'll move into it someday. So again, that's kind of far afield, but if you think about, there's other ways to do it. And oh, by the way, maybe you wait a couple of years. Of course, you did not make this decision up front. Mom can always forgive the note, or she can forgive it over time. $14,000 a year. And there's some other, again, I don't want to get into discounting strategies, but let's just say that this is broken in half, right? This is worth $1 million. And I take a laser beam and I break it in half so perfectly that you can't see any chips or anything, and I put it back together. If I give you half of it, is that half worth $500,000? No. The IRS recognizes that same principle with real estate, okay? So maybe instead of selling you 100% of the house this year, she sells you 5%, and she keeps 95%. You can easily, and you have to have it well documented, and this is something that the IRS will look at, but you've now turned a $7 million asset into perhaps a $5 million asset. And you've solved either a gift or an estate tax problem. So there's lots of stuff that you can do. You're not going to get this, and I mean, I'm going to, basically you're not going to get this at LegalZoom, right? Maybe someday, but not right now. Anyway, so let me finish up with this. Beware of losing the parent-child exclusion. I have clients who basically say, they're giving the property to, they've got 3 kids, and they're giving it basically to all 3 kids, 1/3, 1/3, 1/3, and one of the kids says, I want out. I want my $2 million. I don't want to be a landlord with the 2 of you. I don't want to do it together. So buy me out. There's a way to do it without causing property taxes to go up, and there's a way to do it with property taxes going up. If you buy the house from your sibling, that is now not a parent-child transfer, it's a sibling-to-sibling transfer. And that portion of the property is going to get reassessed. If it's done while the property is still in a trust, there are ways to get a mortgage. You cannot be the person who lends the money, but you can get a mortgage, basically, the mortgage money goes into the trust, and the mortgage money is then transferred to the sibling that wants out. You take the house subject to that mortgage. So yeah, you're going to be paying somebody back on the loan, but you get to keep the house and you get to keep that same property tax exclusion, which, I mean, you know, if we're talking a couple of $1,000, it's not worth it. A $60,000 swing, maybe it is. You can also get grandparent-grandchild exclusions. They're more difficult. There's a lot more technical requirements, but it is possible to do. I did want to mention one more issue on parent-child or grandparent-grandchild exclusion. I said that residential property is different from investment property. Investment property, the rule is that you can only transfer $1 million worth of investment property without triggering a reassessment. But in the legislature's wisdom, the next question you should be asking is, well, how do you compute that $1 million? It's based on the assessed valuation of the house the day before the transfer. So back to Mom bought the house Mom bought the commercial building in 1963 for $50,000, and today it's worth $7 million. It's been reassessed every year, right? And the property taxes have gone up. But if you look at the property tax bill, what it shows is that the building and the land is worth $250,000. Mom can basically, you can protect another $750,000 from reassessment, because the assessment value is only $250,000, even though the retail value is $7 million. And oh, by the way, Mom and Dad both have that $1 million. So even if Dad died 5 years ago and left the property to Mom, you can still get basically Dad's exclusion as well. So and again, you lose it if it's a sibling-to-sibling transfer. You can also lose it in an LLC. Okay, so you've got to be careful of some of that. I think this is basically the last slide, and it's a little bit tongue-in-cheek. 5 more minutes?
Yeah, then we can take some,
Okay, great. Just, I get people all the time, I mean, I've mentioned it a few times here, they think they're going to save a lot of money by doing it themselves. It's short-term thinking. I tell people all the time who say that they don't want to do something great, here's my card, give it to your kids, they're going to need it. There are no do-overs, right? You can't screw it up, you're dead, and then, basically, oh, well, let's fix it. A la carte is inexpensive, or is expensive. Being cheap can cost you more. I mean, and one-size-fits-all solutions aren't. There's lots of different situations that you need to be aware of. I'm not going to diss Nolo Plus, LegalZoom, and prepaid legal plans. Again, they're great for the right circumstances. If you truly have a simple situation, Nolo Press does a good job. The problem that I see with the do-it-yourself stuff is that you don't think the thought process through completely. You'll do something like, basically, I've got 2 kids. I leave half of my estate to my daughter Susie, and let's just assume there's no grandkids. I leave half of my estate to my daughter Susie. If she dies, I leave her half to my son Sam. I leave half of my estate to my son Sam. If he dies, I leave it to daughter Susie. What if they both die at the same time? Then who gets it? Now, if they've got kids, that can be taken care of. But I'm probating an estate, well, actually, we finished the probate. My fee was, my ordinary fee was $63,209.26. In addition to that, I was able to get what are called extraordinary fees, basically because I did things that were not considered routine in the probate. We had four pieces of real estate to sell. The court awarded me another $22,000 or $23,000 for that. The gentleman who died, actually, I had probated his brother's estate, and he had me do a trust for his 93-year-old mother, so that when she passed away, there was no probate. At that point, his brother was already dead. His brother didn't have kids. Basically, 4 houses in Mountain View went to him, free and clear. For 2.5 years, he was going to do a trust, and he never got around to it. He passed away, and one of his cousins, who he had always, well, I better not say this because God knows who's going to hear this. One of his cousins became the trustee. There basically 10 people inherited his estate. Basically 10 of his cousins inherited his estate because he didn't have kids, he didn't have siblings, he didn't have parents, and all of his aunts and uncles were dead. So his nearest surviving relatives were 10 cousins. One of the cousins was the illegitimate daughter of one of his mother's brothers. Had never been part of the family, but she is a blood relative, so she got it. 3 of the other cousins were basically the children of his, they weren't half siblings, so let me think. They must have been children of his uncle's second marriage, who he had never met.
Is this real life or so?
Oh, this is totally real life. Oh, you don't have to.
I thought that you're describing a reality show.
No. It is a reality show. Trust me. I don't have to make it up. Trust me, I don't have to make it up. I mean, yeah. I called a woman. We did some, and we have to try to find the heirs. So I found this woman. I knew what the cousin's name was because my client, the executor, told me, well, he's got a cousin named whatever, Susie, and I think she lives in Sacramento. So I basically did some fairly simple searching, and I found like 4 people with that name. It was a pretty common name, like Smith. That wasn't the last name, but it was a fairly common name. So I did some fairly simple searching, and I sent a letter to the 4 people that I found in the Sacramento area that had that name, and basically, you know, one of these things that you think is a scam, please give me a call because you may be an heir to an estate. Right? How families work. One of the other people I was looking for was her sister. I didn't actually know it was her sister. No, I take that back. I didn't know she had a sister. My client didn't know she had a sister. She didn't bother telling her sister about this, so an heir chasing firm found her sister. So let's say, you know, Sally, the woman that I found, basically gives a call. What's this all about? Is this real? And it's like, yeah. Your cousin died. The estate's worth about $2.6 million. It's going to be divided. Well, we thought it was going to be divided 9 ways. So when the probate's done, you're going to be getting a check for, you know, someplace around, you know, $250,000 to $300,000 minus whatever the costs are. Her sister, she didn't bother to tell her sister about this. So her sister signed up with an heir locating firm that took 25% of that. But I don't know where I was going with that story. Anyway.
You need an estate. Trust.
You need to do some
trust,
planning. I mean, I guarantee you my client did not want his estate to go to 10 cousins, 4 of whom he probably had never met. On the other hand, I happen to know that he was corresponding with basically women in Russia who were trying to get him to come over and marry him. So maybe this was the better solution after all. That's pretty much it. If I've got time, if I'll take questions.
We have 5 more minutes for
5 more
questions.
minutes?
Yeah,
Okay.
let's do that. Yeah.
Oh, before you go, thank you for sitting through this. I have a survey that I'd like each of you to fill out, and this is a $50 Amazon gift card. If you want to put your cards or your names in the hat here, I will draw a card out of the hat, and whosever name I draw gets this. I think, let's see, did Alicia, I guess Alicia left, my assistant's already left. I'd really appreciate it if you would fill out the surveys and let me know if there's anything else you'd rather hear about, if I ever speak again. I think there's more in here. Does anybody have questions? Well, yeah.
We have some questions. Do you have an email or?
Oh, yeah, the last slide. I do give a free 30-minute consultation. If you want to set it up, you can call my assistant. Her name is Cheryl. The number is 325-8276. Or you can send an email to me, janet@calprobate.com. I work with another attorney who couldn't be here tonight, Inat. You can also contact her. Other questions? Okay. When Danny finishes passing that around, I will pull somebody's name out of the hat. Thank you.
Thank you.
If you need a pen to fill out the survey, I've got pens.
2 more minutes. Before you head out, just a couple of things. First of all, you'll still be here for questions.